Hey everyone, welcome to lesson number 4. Congratulations, you now have your client under contract, whether it's a buyer or a seller. You have that representation agreement filled out. But now, the really exciting part, you're about to write an offer. This is more typical for a buyer to be writing an offer. However, a seller can still write an offer as well, but we're going to pretend that you're representing a buyer in this situation to go ahead when fill out the purchase contract. So let's dive right into it. So we're in our buyer showcase template that we created, or transaction kit. We're going to click on here and do a search. Now remember, for this scenario, we're pretending it's a single family home. If you were to look at purchasing a condo or any condominium, you would then be using the condo template, and the purchase contract would look slightly different. However, it would be relatively the exact same. But let's dive right in. So, as you remember, things transfer flow through as you're completing them from document to document to document. So you'll notice that it already has your contract number, already has the buyer's names listed here. However, I would recommend this to be a different contract number than the one that you have for your representation agreement, as this will connect to any amendments, waivers, non-waivers, addendums, or additional forms, which we will be learning about in our next lesson. However, this would be this. I typically use the MLS number as the contract number. However, you can make it anything you want as long as you can remember what it is, because that's what's going to be going through to your documents carrying forward. So I'm just going to write MLS number. This is then where you would input the seller's name. So again, you would put the seller's name that's on title. If you don't pull title beforehand and you don't know the seller's name, it should be listed on MLS. However, you want to make sure all that information is correct. So it is best practice to pull title prior to writing your offer. Then this is where you would put property address. Again, right, city of the property, postal code, pretty self-explanatory. This is then where you put the legal description. Legal description, again, is found on title. It's also found on the tax report, and it should be listed on your MLS highlight sheet. So pretty self-explanatory. Plan, block, lot. Unattached goods, as we talked about, is your refrigerators, microwaves, stoves, furniture. So anything that's attached to the home, or that is not attached to the home, or would cause damage to remove from the home. So there's usually a list on your MLS highlight sheet of what the seller is offering. You can copy and paste that and put it here, or you can type it out. And if there's anything additional, make sure you read it, because sometimes a seller is only offering a dryer but not the washing machine. So you want to make sure that your buyer is getting everything that they're anticipating. So make sure you go over this list with your buyer prior to submitting your offer. But all the goods to be included. This is, again, the seller would have put something on there to say whether it was being excluded from it. So if there was anything in there, or anything that your seller or your buyer did not want to have included in the sale and they wanted removed, this is where they would put it. This then is your initial, it won't let me put a number, but in this section is where you would write your initial purchase price. Again, you may very well get countered. If you're doing your best and final, best offer right off the bat, then you would put whatever your purchase price is there. So we're just going to put 400,000 as an example. This is the specific date that they would like to have the purchase contract, or have as a possession date. So it has to be a date, and it has to be a banking day. So it cannot be December 25th, January 1st, September 30th. None of those dates are banking days, can't be on a weekend. So make sure you pick an actual business banking day. It is also good practice to not have it on a Friday. Reason being, if something goes wrong on the Friday, they then will not be able to close until the following Monday. So that can cause some extra payment delays. However, if you have it on a Wednesday or a Thursday, then if there is a delay, they still have the next business day to figure everything out. Plus, then it still gives them time to move over the weekend. So for this example, we're just going to pick a random Wednesday. General terms. So make sure you read this. So in fulfilling this contract, the seller and buyer agree to act reasonably in good faith and agree that. Have a read. These are all incredibly important, essentially meaning that they are going to operate in good faith, be honest and transparent with each other, and that they have legal ability to sell, all of those sorts of things. The big one, as we talked about in the listing representation agreement, the seller will ensure the seller's representative and warrants are true by reviewing documents such as real property report, RPR, land title and registration on title, determining non-resident status for income tax purposes and determining any dower rights, and doing any other needed research. This, for next filling out, is who is going to be responsible for doing any conveyancing on the deal. So in Lethbridge, Calgary, Edmonton, all of those boards, it is incredibly common for the seller's brokerage to be the one to do it. So this is where you would write sellers. Because you're putting the sellers here, means the listing brokerage should be the one that's holding deposit. There are very few circumstances where the buyer's brokerage would be holding it. If you do that, then you would put buyers up here. However, you would normally put the listing brokerage. So listing brokerage. This is how much they're putting it as an initial deposit. So on a $400,000, it would be very common to have a $10,000 deposit. This then needs to be the method. So are they doing it via e-transfer, bank draft, check? Those are the three most common. Some brokerages allow wire transfer. We do not allow wire transfer to receive deposit, but we do accept e-transfers, bank drafts, and checks. So you could go e-transfer, bank draft, check. This then has to be a specific day. It is not illegal, but it is not best practice to put 2 business days after acceptance, 3 business days after acceptance. Don't do that. Pick a specific day. The reason is it gives clarity to the contract. You then know with the exact date that it needs to be handed in by. It removes any potential confusion. So use dates. So in this case, where we're going to be writing it on December 8th, we will give until the 15th. All of this is, of course, negotiable between the buyer and the seller. An additional deposit is if you're doing a second deposit on top. So if it's a longer possession, the seller may request to have multiple deposits. If you're taking money out of an RSP for it and you need just a few additional business days, you might do a small one up front and then another one at condition removal. There's a bunch of different scenarios for deposits, but know that you do need an initial deposit. Additional is not required, but it could be part of the purchase contract. 4.5 is incredibly important. If the buyer fails to pay a deposit by the agreed date, the seller may void this contract at the seller's option by giving the buyer written notice. The seller's options expires when the seller accepts the deposit, even if late. This means that because you put a specific date, either here or here, if the buyer does not bring in the deposit within that time frame or by that date, the seller has the right to void the contract. So it protects your seller, it protects your buyer to know when everything is due by having specific dates. It creates complete confusion if you put 3 days after acceptance and there's been a bunch of counters and you don't know exactly when it was officially accepted, and then there's just problems. So put dates in here. And just know that if your buyer does not bring in the deposit to whichever brokerage is listed above, the seller may void the contract. And know that as soon as that's brought in, the seller no longer has that option. Even if it's brought in 5 days, 6 days, a week late, doesn't matter. The seller loses their option to void the contract as soon as the deposit is received. Best practice, get your deposits in before the date. Then you never have to worry about it. The trustee will deposit all funds into a trust account within 3 business days of receipt. Interest on deposit will not be paid to the buyer or to the seller. Deposits will be held in trust for both the buyer and seller. Provided funds are confirmed, the funds will be dispersed without prior notice as follows. So basically, we complete the contract. So if the buyer goes through with everything, we send it off to the seller's lawyer. The big one is that to know the buyer, if they do not remove their conditions, will receive their deposit back. If the buyer removes their conditions and then does not complete, the deposit will go to the seller. If the seller does not complete, but all conditions were removed and the seller does not complete the sale, the money will go back to the buyer. Fees can be taken out of it, and that's where it talks about here. Applied against the fee owed by the seller by payment directly to us of our trust brokerage, with any excess being paid in trust to the seller's lawyer no later than 3 business days prior to closing. Fee means the amount plus GST owed to the real estate brokerage under a written agreement. So what the listing commissions would be. Land titles. So know your land titles. Everything has to be free and clear to transfer title over. That means there can be no caveats, no outstanding liens, no encumbrances. Nothing can be on title to transfer over to the new buyer. So know that. Representations, the seller has the legal right to sell the property. The seller is not a non-resident for the purposes of Income Tax Act. No one else has a legal right to the included attached or unattached goods. The current use of land and buildings comply with the existing municipal land use bylaw and restrictive covenants on title. The location of the buildings and improvements is on the land. Known material latent defects, if any, are disclosed in writing and in this contract. So that's where you would include the defect disclosure agreement. You would have that be part of this contract. Any government, local authorities. So again, we go down to dower 7.1. Dower can only apply if there's one person on title and they're legally married and they've lived in the property. If there's 2 people on title, never worry about dower. If it's corporation, never worry about dower. If there's one person and then it goes on to the responsibility of the seller to complete and fill this portion out. As the buyer's agent, you do not fill this portion out. It is to be completed by the seller, and then give you a date of when it is to be completed. Conditions, 8.1. So conditions they kill contracts if they're not met by a certain time. So most common are financing and property inspection. There are, of course, potentially hundreds of other conditions that you can include, all dependent on your buyer's or seller's situation. So most common, again, financing. Don't worry about the exceed piece. This is where you put the time, PM. Again, everything is negotiable. If you're representing the buyer, you want your condition dates to be as long as possible to give your buyer the most opportunity to make a decision. If you're representing the seller, you of course want the condition dates to be as little and quick as possible, because you don't want the property to be tied up, and you want it to be able to ensure that the buyer is actually serious about purchasing. So in this instance, we're again writing on the 8th. Maybe on an initial offer, we'll put it as the conditions to be on the 22nd, right? And we will do the same thing for the property inspection. So this means you'll have to have your home inspection and financing waived or completed by December 22nd before 9 p.m. This means you'll have to send a waiver over to the listing agent prior to that time. Sellers, of course, can have conditions as well. So this is where you could write it out. So you would just say confirmation of probate as an example. Of course, it's 100 other ones that you could do. Same thing, you would do 9 p.m. Let's just do it to be on the same date. If you have any questions about this, definitely always ask your broker. Sale of buyer's home is one that we will go through in our next class. Waivers, amendments, addendums, those are all forms that we will also go over in our next session. These are where you would tie any additional documents into the purchase contract. So if you had a disclosure agreement, you would click other, and then you would just click effect disclosure agreement. This is where then you can put in any specific terms. So having the property get cleaned, having something get repaired. If your fee from your buyer brokerage agreement is not being offered, then you can insert a clause to ensure that the seller fulfills your buyer brokerage agreement. It could be about assuming a tenant. There is hundreds of possibilities of what could go in here. To review what the best way of writing a particular term is, and terms carry through the purchase contract. They cannot kill the purchase contract. So there is an attached form called AB standard clauses or area standard clauses. It will be attached in here as well as it is on Max Central, and it is available through web forms. So read that over. Closing documents. So again, read over 10.1, 10.2, 10.3, 10, like all of your 10s, because this explains the process of what happens for closing. Most closing is done by the lawyers. We as a brokerage send off all of our conveyancing documents. All of that is done by the brokerage that you put up top, that they do all the conveyancing to ensure both lawyers have everything. So please just know and read all of this information. 11.1, the seller bears the risk of loss or damage to the property until the purchase price is paid. If such loss or damage occurs before the purchase price is paid, any insurance proceeds will be held in trust for the seller and buyer based on their interest. Remedies. If a seller or buyer fail to refuse or complete the contract, the other party may seek all remedies, such as claims for deposit and damage and reasonable costs, including legal fees, disbursements on a solicitor/client full indemnity basis. Read over all of this. Read over your notices. This instance, because we're representing the buyer, mine has been pre-filled. Ensure that you fill out the seller's brokerage. So name of brokerage, address of brokerage, right? Name of listing agent, phone number, fax number, and their email address. This is if the person is not represented by a brokerage, and they're represented maybe by a law firm or some other individual that they have chosen to represent them. This is where that would go. 15.1 is incredibly important. Essentially, it states that no contract is valid until it's in writing. Verbal counters mean nothing. Only what's written on the purchase contract is valid. Verbal agreements, emails, none of that. Text messages, none of that matters. It is only what's on the purchase agreement. So this is to be initialed by both of them to state that they both understand that only this agreement is the only one that takes effect. Getting a text message from a seller's agent saying, yeah, we counter at 390 or 310, 410 in this instance, but it's not in writing on the purchase contract means nothing. So until it is changed and initialed on the purchase contract, does not mean a thing. 17.2, this then states that this offer is only open or valid for a certain time, which means both parties would have to agree prior to that time completing. So if you put 9 p.m., let's just say we're writing this on December 8th. So let's just say I only gave until December 10th for it to be valid. This is where the buyers are signing it. If they're signing it virtually, you just put wherever they're signing it virtually from, and then the date that they sign. This is where the seller would sign for acceptance. If there is a non-titled spouse that has to accept, this is where they would write. And if anyone is rejecting it, either the seller or the buyer can reject, but this is where they would sign as a rejection. This is the information that will be fulfilled on a trade record sheet. You can also fill it out here. However, it will need to be inputted on your trade record sheet regardless of it being completed here. So now you know how to complete a purchase contract. Pretty easy. Make sure you read all the terms, read all the clauses in there. Always have it be reviewed on your first couple before submitting it off. And remember, counters in writing are the only official counters that matter. So make it a good habit of getting your people to write and cross off and counter in writing every single time. That is your best practice, and that will ensure your client's best interest is always being served. Once you have a fully completed one, you then are officially pending when both parties have initialed and signed off on everything. And then that's where the real fun begins. But next lesson, we're going to be learning about all the additional forms like our waivers, non-waivers, amendments, addendums, sale of buyer's home that can also be attached to the purchase contract and that you will need going forward throughout the process of the offer. So I look forward to seeing you in lesson 5 and have a great day, everyone. See you.